Thank you very much, Paul, and thank you everyone for being here. We really appreciate you spending some part of your day with us talking about OSHA's emergency temporary standard. I'm thrilled to be here today with my colleagues Theresa Mongiovi and Angela Sanders, and we're going to walk you through the background of the ETS, which is what we're going to call it for short, and the current legal challenges that you may be hearing about, some of its key requirements. We'll talk to you a little bit about exemptions, both disability and sincerely held religious belief, and how to create a process for employees to seek exemption. And then we'll briefly cover the executive order for federal contractors. So because we have a real full plate, we're just going to dive right in. So as you all heard, and it was covered in the media, President Biden on September 9th announced a six-pronged national strategy for combating COVID-19. On that day, he also issued his executive order regarding federal contractors. We have a link to the White House's plan on the slides, and the slides will be provided to everyone after the presentation as well as a recording. So we know we're going over a lot, so just know that you're all going to get copies of that. And here's just a brief timeline. I know there's a lot of going on. There's a lot of moving pieces. And so you see in September, the president issued both the executive order regarding federal contractors and the mandate for employees of the executive branch. Originally, the deadlines for federal contractors were supposed to be earlier, but last week it was announced that the deadlines for federal contractors are going to be the same as the deadlines for the OSHA ETS. So federal contractors have a little bit more breathing room and a little more time for compliance. As you all saw and heard, last Thursday, the OSHA ETS was announced, and then it was published in the Federal Register Friday. So the deadlines count from Friday. And so the first set of deadlines is 30 days from last Friday, November 5th. So we're really dealing with an expedited OSHA process here. Just on the left side, I'm not going to go through all of the details. The standard process for OSHA issuing a rule usually takes months and months and months. And you need to have a proposed rule and a comment period, and then you issue a final rule. Obviously, we didn't do that here. What happened is OSHA used a different process, an emergency temporary standard, and in order to use that process, they need to show that workers are in grave danger, and that standard takes effect immediately, which is why everything is so expedited. There's no full rulemaking process during that period of time. And so we have these issued regulations. They will be in effect and valid until superseded by a permanent standard. So that's where we are in terms of the ETS and the process.
Good afternoon, everyone. I'm going to go over some of the highlights of the OSHA ETS for large employers. As Andrea said, this was issued last Thursday. And there were a lot of busy lawyers over the weekend filing lawsuits and figuring out what was going to happen. So I hate to do spoiler alerts first, but we do have an updated development as of Saturday. The question that all of you are asking, is this vaccine mandate going to survive? That's really the big question of the hour, but we're going to update you on what has happened just since last Thursday. So basically on Saturday, November 6th, the Fifth Circuit, which is located in New Orleans, granted an emergency stay, in part based on there are a number of petitions filed by multiple states, attorney generals from multiple states, businesses and advocacy groups, and they were smart enough to bring their petition before the Fifth Circuit. In a 2-page order, the Fifth Circuit indicated that they believe a delay is necessary because of potential grave statutory and constitutional issues. Specifically, Louisiana AG Jeff Landry has been quoted basically indicating what some people think about this ETS, that it's a basic problem with the checks and balances. That is one of the core elements of the lawsuits that are being filed against the enforcement of this particular agency, ETS. As of yesterday afternoon, President Biden's administration, as well as the Department of Labor, filed emergency responses that were due yesterday. Yesterday, in a briefing in the White House, there was a recommendation that businesses should still move forward with the requirements despite the court-ordered pause. So what happens next? Just because a stay is issued, we're still presenting this information to you. It's uncertain what's going to happen at the next level because there have been a number of lawsuits filed in various circuits. What happens is there's a lottery system between those circuits so that there's a decision as to who is going to make a decision on an injunction request. An injunction request would stop the temporarily, at least pending the outcome of this lawsuit, this from going in place. So this is going to be evolving on a daily basis. We will continue to update you, but we feel strongly that given the complexity of the ETS, that it's important for all of you to understand what the rules are so that you can begin making very specific strategic decisions in your businesses about how you will have to comply with this. So, general, what is the ETS? What's it about? Basically, the requirement is that every employer, every large employer, which is defined as anyone with 100 and more or more employees, which we'll go into more detail about, is required to develop, implement, and enforce workplace policies that would either require mandatory vaccinations for their workforce or permit employees to choose a vaccination status, decide whether they're going to be vaxxed or unvaxxed. But if they're unvaxxed, the employees must wear face coverings, and we'll talk about more specifics about what that means when they're indoors or when they're in a vehicle with another person for work purposes. They will have to test at least weekly if they're in the workplace, which is defined as once every 7 days, or if they're not always in the workplace, they're working remotely, but plan to come back to the workplace to even drop off papers, do whatever they need to do, they would still need to test within 7 days before returning to the work site. Other elements, besides developing a policy, the first issue that employers have to do is determine the vaccination status of their workforce, maintain records of that vaccination status and rosters. There are paid leave requirements that we'll go into more detail about for those who are receiving their primary vaccination doses during work hours. And there's reasonable paid time off provisions for those who need to recover from side effects. There are also requirements about prompt notification for employees that have COVID-19, and those employees need to promptly notify their employers. And there's also requirements about making the records about the vaccination numbers and specifics available to OSHA within 4 hours of request, or employee reps are entitled to obtain certain but not all of the information that is kept by the employer. So we're going to go into just a little bit of background. You're all going to be seeing and reading about these lawsuits and claims. But one of the things that I found to be interesting about this ETS itself is that a significant amount of the ETS was focused on justifying the grave danger justification. As Andrea already explained to you, when we're working with an emergency ETS, there's a very limited process of review and comment. And as a result of that, the underlying need for the ETS has to be justified by a grave danger. If there's not a grave danger, then OSHA would need to go through the normal rulemaking process, which would involve public notice, comment, information from stakeholders. So this particular ETS spends a significant amount of time identifying what they are saying is the grave danger for this ETS. And they cite specifically in the ETS the fact that COVID has killed over 750,000 people in the US, that they believe that this ETS, by applying to employers with 100 or more employees, will reach about 2/3 of all private sector workers. They have made a finding that unvaxxed individuals are at a higher risk of severe health outcomes from COVID, and unvaxxed workers specifically are more likely to contract and transmit COVID in the workplace, and that they themselves face grave danger from exposure in the workplace. So a lot of the grave danger justification is focused on the unvaccinated worker. They indicate specifically in the ETS that reliance on OSHA's, quote, general duty clause and workplace guidances that have been issued by the CDC and other entities are not adequate for the protection of those unvaccinated workers. The other piece of the ETS that is interesting, and you'll be hearing a lot about this as these lawsuits make their way up the chain and probably to the US Supreme Court, is that the ETS spends a fair amount of time going over a specific feasibility analysis, meaning, is this ETS capable of being done as proposed? The definition of that is that that they would need to show that the ETS can comply with the standards in most operations most of the time. That's the threshold of what needs to be established. And there are hundreds of pages of justification by OSHA from every facet, evaluating both the technological and economical feasibility of this ETS, which is specifically in the ETS, which I think is a strong indicator that there was a understanding that there may be lawsuits filed as a result of this ETS. And they basically conclude that they don't anticipate there being feasibility issues. One of the specific areas that I know a lot of you concerned about is how are we going to get tests in order to implement this ETS if in fact we choose not to do a mandatory vax policy. And basically OSHA went through in great detail saying why they don't see that being an issue. But they also indicated that some people's concerns that if we require people to test, we might lose them to other employers. They indicated the risk of losing employees could actually be counterbalanced by an influx of potential workers. Specifically, OSHA did spend some time saying why they believe that this is feasible for employers with 100 or more, because they believe that you all have the administrative capacity to implement the requirements, and that at this point, they're not sure that smaller employers could do so. Two particular issues I know some of you are going to be asking what's available to us, and there's a lot of different roads, but some of you who spend your world dealing with OSHA know that there are two types of variances that are typically available. One is a temporary variance, and this would be for any type of OSHA standard, where basically you can get up to a year of time. You'd have to show that there's an unavailability of professional or technical personnel, materials, or equipment. You have to demonstrate to OSHA that you're taking all steps available for safeguards and that you're implementing everything you could ASAP. I raised this slide only to show that a lot of people are concerned about the availability of testing. I think it's too soon to tell whether that's going to be an issue, since we won't have to really be testing potentially until January, but this might be something that is revisited in some areas if those tests are not available. Permanent variances, I think, are going to be very difficult to obtain in this situation. And there would have to be some very specific, unique issues that would be going on in a workplace to get a permanent variance from this particular ETS. One of the other things that you might find interesting is that, so Andrea explained to you at the outset about what the normal public comment process would be for a normal OSHA standard. OSHA makes clear that although this is an ETS, this is a temporary, emergency temporary standard, that one of the issues is that they want to know whether the standard should be adopted as a final standard, and they are under kind of going the public comment piece of what they would normally do for the typical type of standard. And there were specific questions that they're asking for comment on by stakeholders, including you. They want to know whether this ETS should be adjusted to include small employers. They want to know whether there should be a strict vax mandate instead of a tested mask. Costs, they're very interesting in costs. Are we having difficulty finding tests? Are there other types of vax verification other than what they're requiring, which we'll go into? Have we experienced decreased infections? What's been our experience with reasonable accommodation strategies, which we'll also talk to you about? Have we been offering, or are we going to offer leave beyond what is required by this ETS? And what I found to be a little bit interesting, but also alarming, was one question: should testing be required more than on a weekly basis? So I know a lot of you are very concerned about how in the world are we going to test our workplace in 7 days. So OSHA is specifically seeking guidance as they evaluate whether this, if this ETS actually goes into place, whether there will be some revisions of it as we go down the pike.
Okay, so question, when do we have to worry about this? Well, now, without repeating what Andrea and Theresa have said, we don't have the benefit of taking a 60 to 90 day period to see if this is going to become the rule. It is the rule pending the outcome of the court case, which is on an expedited basis. How long are we going to have to live with this? We're not sure yet. There's 3 circumstances where this may come to an end. By some miracle, in 3 months, COVID could be gone and it could be withdrawn. I wouldn't hold my breath for that. If new science comes out or new recommendations come out from the CDC, it can be adjusted and amended. Certainly, some of the comments and feedback may fuel that. And I would certainly think that updated guidance from the CDC would be taken into account. Or, as Andrea initially pointed out, a temporary standard has a 6-month lifespan. And so realistically, if this is still in place in 6 months, which I'm not a crystal ball reader, but seems to be the case based on where we're at with COVID, they're looking to adopt this as a permanent standard, which again, that permanent standard would be subject to being withdrawn or terminated as COVID changes and the world around us changes. And hopefully we get to a place where this is not in pandemic stage. OSHA, they're very good with their graphics. They have provided sort of this lovely chart, which is accessible on their website. And we can also send out to all of you, that hits the major requirements that we're going to talk through today and when you need to worry about it. So within 30 days, and 30 days in November. So we're looking at December 5th for pretty much everything except for the testing requirement. So there are a lot of pieces that you need to be working on now. And our recommendation has been that you start working on this and not, sit on your hands while the court case is pending. And then you find out on the 27th day that you have a lot of work to do. But this is a nice graphic to kind of give you an outline of what is coming. Now, getting into the meat of the ETS and what we need to be really thinking through for our workforce is, who does this cover? Am I a covered employer? Well, most of you are on this webinar, I assume, because you've made a reasonable conclusion that you probably have 100 or more employees. But to give you a little more detail on that, and actually to answer some of the questions that have already come up in the Q&A, the ETS applies to what are being called large employers, and that is defined as 100 or more employees of the entire business. So this isn't a case where we can say, well, we have 3 locations and each location has 20 or each location has 40. It's across the entire company. And that includes all of our locations. It does include part-time employees. It includes minors. So if you have those workers, you need to take them into account. It also includes temporary and seasonal workers. And when I say temporary workers, I mean temporary workers that are your direct hire temporary workers. So someone that you've brought on for a 3-month commitment that you are, for whatever reason, not calling seasonal. If they are working for you while this ETS is in effect, they need to be counted. And that question comes up, well, what happens when sometimes we have 80 people? And sometimes, perhaps if we're retail, we have 130 people because we do a big hire around the Christmas holiday. The rule is, if I boil it down very simply, if you hit 100 while the ETS is in place, you're subject to it even if your census drops below 100. So if you have 100 or more on November 5th, you're subject to it the whole time it's in place. If you have 80 on November 5th and you do a big hire for the Christmas holiday and now you're at 110, you're subject to it when you hit 110. If you let go all those extra people in January because Christmas is over, you are still subject to it even once you fall back below the threshold. So if you're somebody who's borderline, you have to really think through potentially your hiring strategy and whether you're going to bump yourself up into this number, because once you hit it, it's going to stay. One of the questions in the Q&A was, how do we deal with temporary employees that are supplied to us by a staffing company? OSHA has published frequently asked questions and some additional guidance, and the answer is that staffing company employees who are working, you're the host employer, but they're working in your plant or your location, are to be counted by the staffing company as opposed to the host employer. So staffing company counts them. If staffing company has 100 or more staffed employees out at various clients, then the staffing company is covered. However, if the host employer only has 80 of its own permanent direct hire employees and it has 30 temporary employees that are coming through a staffing company, the host employer would not be covered in that scenario. And then the last point on counting is multi-employer work sites. That's typically a big issue in construction settings where there's multiple subs. Each company is to count their own employees. So even if the aggregate at the work site is 100 or more, if you're a subcontractor and you only have 20 employees total, you are not going to be covered simply by virtue of the fact that you're on a work site with 100 plus other people. I won't go through this in painstaking detail, but there is a list of employees that the employers that the ETS does not apply to: state and local governments, federal agencies. If you're a federal contractor, you are not covered by the ETS because you are covered by Executive Order 14042, which we're going to talk about quickly at the end. And if you are a healthcare employer who is subject to the, we'll call it ETS 1, the ETS that came out in June that laid out different requirements for healthcare employers and the protective measures that needed to be put in place, you are not covered. And then there are two additional categories: remote workers and workers who are outdoors, that Theresa is going to go into some detail about.
So one of the specific elements of the ETS is that those employees that are working exclusively outdoors, they have found have a lower risk of exposure and transmission and would not need to follow the ETS. It doesn't mean that the company itself is exempt from the ETS. It just means that those employees would not necessarily be made to either make a choice to vax or to not vax, but to mask and test. What does that mean under the ETS? Well, the definition is any occupation where workers are outdoors constantly, which OSHA interprets as being nearly continuously outdoors. It's one of those cases where the interpretation isn't much clearer than the original word, is it? But basically, they have to work outdoors on all days, working sometimes indoors on some days and sometimes outdoors on other days is not acceptable. They must not routinely occupy vehicles with other employees as part of their work duties. And any work, they have to work outdoors in every workday except for de minimis use of indoor spaces. And that would be examples of multi-stall bathrooms or very quick trips in for admin, but that, you know, clearly it is supposed to be a very minimal amount of time indoors. It has to be brief or occur exclusively in an employee's home. Outdoors does not include buildings under construction where substantial portions of the structures are in place. So I know those of you who are on work sites are saying, well, is it outdoors if we have the walls up but the roof's not on? They've answered that question. They basically have said that, for example, walls, ceiling elements that would impede natural flow of the fresh air at the work site would not permit you to claim this exclusive outdoor issue. There's been a significant amount of discussion about the trucking industry. Labor Secretary Walsh recently made a statement in the past day or so indicating that most truck drivers would be exempt from the mandate, but not if they work in teams or they interact with people in a building or at a destination or starting point. So if they're loading trucks with a bunch of people, if they are unloading trucks at the destination where there are people around, then that would be an issue. So the trucking industry has been greatly concerned about this. On the next slide, this is actually a chart that is in the ETS, and it's take a look and see if it applies to you, but basically it's an estimate of the number of workers that would be subject to the outdoor work exemption, which they reviewed in their feasibility examination. And they specifically listed a bunch of different occupations with their SOC codes and identified the percentage of outdoor work that they believe people would be doing constantly and the amount of work that they'd be doing outdoor exclusively. So this is somewhat of a guidance if you're in some of these industries as to what perhaps the presumption would be if you have different facts about how your jobs are different. That's something that we can assist you in evaluating.
Okay, someone has asked in the chat about the healthcare ETS, and I did mention it a moment ago. So back in June, OSHA issued another emergency temporary standard that covered healthcare employers. It was not a vaccine or test standard. It had, frankly, a ton of information, and I'm not going to go through it in painstaking detail here, but it had to do with protective measures, all kinds of physical things that needed to be done to the workplace to stop the spread of COVID. It had to do with removing individuals when they had positive tests. It had payment obligations if you had to remove a worker because they came into or because they were COVID positive. This ETS that we're talking about today is very different, but OSHA has made clear that you are not subject to both. So if you are a healthcare employer and you are already covered by the healthcare ETS that came out in June, you are not covered by this new ETS unless a couple of things happen. One, if in some bizarre set of circumstances, the healthcare ETS would go away, you might then have all your people come under this one. So what they're saying is you don't have to do both, but if one falls off, you may be stuck with the one that's left behind. The other important thing is that the healthcare ETS is pretty easy if you are a healthcare facility providing on-site patient care, but there are other healthcare providers under that first ETS that are different. So for example, a large national retail pharmacy, a Rite Aid, a CVS, a Walgreens, that is basically a retail store with a pharmacy inside. The healthcare ETS only applies to the pharmacy piece, and this ETS, the vaccine or test, applies to your remaining employees. So you could be in a situation where you have to follow both. There are also rules in place for multi-level care retirement facilities where the healthcare ETS may apply to some pieces, but not others. And in that scenario, you might have to be looking at both. But if you are a healthcare employer where 100% of your employees are covered by the first one, you don't have to worry about this one just yet. Although we will talk for 2 seconds at the end about another regulation that may impact you.
Sounds real easy, right, Ange? So what are the action items? We've given you all the background of what are our timelines, who does this apply to, what are the things that you need to be thinking about in the order of importance. Step 1, we need to be determining the vaccination status of our workforce. We have to require all employees to provide an acceptable proof of vaccination status, including whether they are fully or partially vaccinated. There's a very exhaustive list that I'm not going to read them to you, but there are specific issues that acceptable proof mechanisms and the things that have to appear on it. You must look at this and make sure that the types of proof that you're receiving meet with these acceptable proof items. Maybe this will be expanded, but at this point, these are the things that we're allowed to use to determine whether someone is fully or partially vaccinated. Now, I know that many of you work with people as HR people, and I don't know about you, some of you just might have situations where people forget to bring things in or lose them, right? I think they recognize that, and there's a specific provision in the ETS that if somebody's VAX card or other proof was lost or stolen, first, they want you to have them contact a VAX provider to obtain a new copy. Many states have Department of Health immunization info systems where this information can be obtained by the employee, not by you, the employer. But if they're unable to produce acceptable proof, you can accept a signed and dated statement by the employee, which includes the type of vaccine, date administered, who administered it, where was it administered, and most importantly, an attestation that the employee is unable to produce another type of proof. I assume some of you may be in this boat for people who've already lost their VAX cards. Forms of proof. So does it all have to be paper? What are we keeping? It can either be a physical copy of a VAX record, or it can be a digital photo, scanned image, or PDF, but it has to clearly and legibly display the necessary information. If it's not a good picture, it shouldn't be accepted, and you need to get more specific information. There's discussions about fraudulent records. We've all been hearing about instances where people have been using fraudulent or fake VAX cards in too many places. What is an employer supposed to do? What's their obligation? Well, the first is that you can't invite or facilitate fraud and tell employees that they can make whatever they want and that you'll accept it. You also are not required to monitor for or detect fraud. If you know that the proof submitted is fraudulent, or you accept and maintain a fraudulent proof, then you, as the employer, are going to be subject to criminal penalties. The employees also can be subject to criminal penalties. And we've actually seen those occur in Pennsylvania within the past month or so. So you're not obligated to ferret out every lead, but you certainly can't accept, invite, or if you know that it's fraudulent, you can't let that stand. After you have determined the vaccination status of your employees, you have to actually prepare a roster, which is a list of all employees, and you need to indicate whether they meet one of four statuses. Either they're fully vaxxed, which we'll talk about, they're partially vaxxed, they're not fully vaxxed because of a medical or religious accommodation, and Andrea is going to go into that in more detail, or they're not fully vaxxed because they've not provided acceptable proof and we're waiting for it. For those of you who've already done this in your workplaces, if you've obtained vax statuses prior to the ETS and you've retained those records, you don't need to re-ask the employee to submit that information. You can transfer that information onto your roster. What is fully vaccinated? Everyone is asking, what do we do about boosters? We used to know what fully vaxxed is, and then the booster element came in. Well, under the ETS, fully vaccinated is still defined as 2 weeks after completing the primary vaccination with the COVID-19 vaccine with at least the minimum recommended interval between doses in accordance with the approval. Obviously, if it's the J&J, it's one dose. If it's the Pfizer or Moderna, we're doing 2 doses. It does not include booster shots and additional doses. And we probably should have put in parentheses yet. At this point, that is not something that we have to think about. Maybe that will change as this progresses. Exceptions to fully vaccinated is where it's medically contraindicated. The doctor says, I don't want this person to have this vaccination. There's some type of medical necessity that requires a delay in vax, that the person can get it later, but they can't get it right now, or they're legally entitled to a reasonable accommodation due to disability or a seriously held religious belief that Andrea will discuss in greater detail. Just to be clear, under the ETS, if someone has had a prior COVID infection, there is not a recognition in this ETS of natural immunity or the presence of antibodies for someone that obtained those antibodies because of a prior COVID infection. So that is not an exception for someone to say, well, I just had COVID. It's not an exception from the vax or testing and face covering requirements.
Sorry. Thank you, Theresa. Now we're going to focus on the policy, developing that policy and what's required under the policy. So the ETS does not require vaccination, right? If you as an employer decide that you want to mandate vaccination with exemption for religious and disability, and you don't want to have a testing regime, you can do that. You're not required to do that. You certainly can provide for the testing. And obviously, I know lots of you out there are very concerned about going the complete vaccination route because you're concerned, given the percentage of your workforce that's unvaccinated, that you're going to lose workers. So ultimately, you can do that, but the first step is to figure out what is it that you want to do, how do you want to craft your policy, and then you have to put in place a policy. If it's mandatory vaccination, you're not required to continue to employ the person. So if you want to decide everyone has to be vaccinated, and if people don't give you an exemption form, you can terminate employees if you choose to do so. We've seen a lot of litigation in the courts challenging mandatory vaccination policies, and they have almost exclusively been unsuccessful, those litigations. So other requirements for policies and for information that employees need to be provided. So the ETS is very specific and indicates that an employer needs to inform an employee in language at a literacy level the employee understands, the policies and procedures that the employer has established, the process that's being used to determine if the employee is vaccinated or not vaccinated. So what they need to do with their card, when their cards need to be received. They need to be told what the requirements are of the ETS in terms of the time that employees are going to be given to get the vaccine if they haven't already gotten it, and the paid leave that employees are going to receive if they have some sort of reaction to the vaccine, the procedure to follow for providing notice if an employee is tested positive, the procedure to be used for requesting and obtaining records, and additional information to unvaccinated employees, including testing and face coverings. So the ETS specifies exactly what needs to happen in terms of testing and what type of face coverings are required if the employee is not vaccinated. So we have links on this slide to the information that needs to be provided, the key things to know about COVID vaccines, and prohibitions against retaliation against employees for reporting work-related injuries, and also criminal penalties associated with knowingly supplying false statements. And the website has the fact sheets available in English and Spanish. Know that if you have a substantial portion of your workforce that speaks a different language, you need to provide these notices in the language of those employees if they do not speak English or Spanish as a primary language and can't understand the English or the Spanish notices that are being provided. The content of the policy, again, the ETS is very specific as to everything that needs to be included in the policy. The requirements for vaccination, and specifically the exemptions from the policy, what an employee needs to do to seek an exemption for disability or medical contraindication, as the ETS states, or medical necessity requiring delay in vaccination, as Theresa covered, and then also reasonable accommodations for disabilities or sincerely held religious beliefs. How vaccination status will be determined and how the information is going to be collected. And again, many of the things that we have already been talking about, the paid time off, the sick leave, if it says hybrid here, hybrid, our new favorite word, right? Hybrid here means that if you have a vaccination and testing regime, you're not just doing vaccination, then you need to have information as to testing and face coverings for the employees who are going to go that route. And then again, all of the other things that I have just mentioned that are requirements of the ETS, notification of positive tests, removal from workplace, the effective date of the policy, what the consequences are going to be if an employee does not comply with the policy, and exactly who the policy applies to. The ETS does indicate that if you have a worker who never comes into the office, and we'll talk about that in a little bit, you can indicate that if someone is completely virtual, never comes in, that the policy does not have to apply to them according to the ETS. Again, deadlines for submitting all the information, and don't forget to append your OSHA fact sheets. We're working with clients on developing these policies, and if you have specific questions as you're working through the policy development, you can feel free to reach out to any one of us.
Okay, so testing. Testing is sort of the piece that I think is critical for employers to consider in what type of policy they want to have. All vax, no vax, or something in between. The general testing rule is a 7-day rule that employees reporting to the workplace who are not vaxxed, must be tested for COVID at least once every 7 days, and then must provide documentation of that test result no later than the 7th day following the last time they gave you the test result. So it's on a 7-day basis. Now, if you're a Monday through Friday employer, that can be sort of a little more easy to work out who's going to do that when. If you are someone who has variable shifts or employees that are not coming in on as regular of a 5-day basis, you're going to have to put some thought into what their 7-day schedule may be so that you're hitting them every 7 days. We talked about this a little bit, but you may have employees who are not coming to the workplace every 7 days. They could be remote workers who only come in once in a while. They could be traveling employees. And generally, if somebody is not going to be coming in to the workplace for a period of 7 or more days, we don't really need a test from them because they're not going to be coming into the workplace. However, if they are coming in at some point in the future, they do need to have a test within the 7-day window before they return. So if you have remote workers, for example, who have some obligation to come into the office, as opposed, it could be scheduled versus unscheduled, they're obligated to come in so many days versus stay home so many days, or they just come and go as they please to pick up work or meet with clients. You need to put some thought into whether you want to rearrange that arrangement with them if this is going to be something that impacts your strategy. So if you have remote workers and they all have to come in 1 or 2 days a week, you may want to look at whether that's necessary or whether you want to stretch that out a little bit to impact the testing schedule. Weekly testing is not required for, Theresa went through this a little bit, employees who are not reporting to the workplace. They might be at home. Those who come in once a month, again, the people who are coming in very sporadically would need to have a test before they come in within the 7-day window before. I mean, basically at the end of the day, if any employee of yours is coming into the workplace, they need to have a test within that 7-day window. That could be because they're coming in every week, so they're doing the weekly testing. It could be because they're coming in once every 3 months, but before they come in and have that interaction at your workplace, they need to have gotten a test within the 7 days before. You need to maintain a copy of each test result as a medical record while the ETS remains in effect. So for those of you who do not have your personnel and confidential medical records ducks in a row, you need to do that. Get your color-coded file folders or your whatever electronic system you're using up to speed, because you're going to have to maintain this. And if any of you have been through an OSHA investigation, you know that they ask for everything. And it's important to keep your medical records segregated so that they aren't going through every piece of paper in your office. In terms of costs, this is going to evolve a little bit, but the basic rule in the ETS is that employers are not required to cover the cost of testing. And I'm going to put a caveat after that, because what that means is you don't have to run out and buy 30,000 tests. You're not obligated to be the provider of the test itself, although, as you'll hear a little bit, you may decide you want to do that. But cost means a couple of different things. If you have a labor union, they may come back and have a conversation with you about whether, there should be some cost sharing, because they don't want all their employees having to go to CVS or Rite Aid or Walgreens every weekend and incur costs. The Department of Labor has given an update that they are going to be issuing guidance on whether you have to pay wages if you make a decision as an employer to provide testing at your site because you get an outside vendor or you decide to hire a temporary nurse to administer your testing. The Department of Labor is going to give us guidance on that. However, if you are in Pennsylvania and you happen to be on any of our recent webinars, you know that there was a recent wage and hour decision in Pennsylvania where security screenings and other reasons that people were required to do screenings before they started their workday were compensable. So if you are providing a testing option at your site and people are doing that either on duty or at the start of their work shift or the end of their work shift, you are going to have a wage issue there, and that's going to be compensable time. That does not mean you have to pay people who decide they would rather go to the pharmacy on Saturday or off hours. And the last point on testing that's important to keep in mind is even if you have employees who receive a religious or medical exemption from being vaccinated, they also still need to test. So when you are doing your accommodation approval paperwork, you need to include in there that they're still going to be subject to other mitigation measures such as masking and testing, and they're still going to have to go through that process unless they come up with some other kind of accommodation request, which could happen. What tests are acceptable? The ETS basically goes through and outlines what the requirements are. It has to be approved and authorized. It has to be administered in accordance with the instructions. The key piece here is that a test cannot be both self-administered and self-read unless observed by the employer or a telehealth proctor. So in English, what that means is an employee cannot give themselves their own rapid home test and read the results of that home test and tell you what the results said, because we want to avoid employees lying about doing it. Not that they would ever do that, but you never know. So if there is a self-administered rapid test, the expectation is going to be they're going to be having you read the results as the employer, or some employers are considering having telehealth providers or on-site nurses who would be there to read the test. In the 400 and some pages that OSHA published with this actually not too terribly long standard, they talk a lot about the fact that OSHA's expectation is that the testing will really primarily be done through point of care locations. So your urgent cares, your retail stores with pharmacies, doctors' offices, and other kinds of clinics. I think that's to be determined. I mean, as an employer, it would be great for us to be able to say, if you don't get tested or if you don't get vaccinated, testing is your problem. And you need to do this on your own time. And you need to go to your local pharmacy and bring me the paper result every so many days. That would be nice for us to say. Whether that's going to be completely feasible between now and January, I think we need to wait and see. I mean, I can only speak for where I live. Right now, a lot of the point of care providers are not making testing available to anyone and everyone unless they have symptoms. So there is a ramp up period, and the White House has talked about how they are really trying to push out production and availability of tests. But some employers are making choices to say, maybe we just need to buy these rapid tests and have them available, or contract with a vendor because we have concerns that our employees are not going to, one, do it on their own time, or two, if they do take the steps to get tested off duty, there may not be testing widely available. OSHA says there is. OSHA's analysis of this is that they believe there is sufficient testing available, and that was part of its feasibility study. However, if we do get to a situation where employers are finding that there is an inadequate supply, or they're using a vendor and actually sending the results out to a lab and there's delays associated with that, OSHA will evaluate the employer's efforts and whether they've made an attempt to comply, whether they've got their ducks in a row with trying to have testing in place, and whether they've done it in the past, and whether they've made a good faith attempt. So again, if I boil that down to plain English, if you sit on your hands and do nothing and then try to tell OSHA, well, we couldn't find a vendor, there's no tests available, that's not going to be compelling. If you've gone through your process, identified your testing procedure, how you're going to do it, and you run into problems that are outside of your control, that may be a different story.
I know many of you are evaluating whether you're going to require employees to test on their own time or whether you're going to develop your own testing protocols. Just be aware, I'm not going to go into this in detail, but the ETS does allow for pool testing requirements where basically instead of each person getting a test, there's a group pool submitted. If the pool comes back and it's positive for COVID, it means that everybody then has to be retested. But if it comes back negative, then obviously you haven't had to waste as many tests to get to the same result. So just be aware that there are provisions in the ETS about pool testing. What happens for situations where employees who have had COVID? Well, basically what the ETS indicates is if an employee receives a positive COVID test or has been diagnosed by a licensed healthcare provider, if the healthcare provider says they have COVID, they may not require the employee to undergo testing for 90 days. Why? Because there's a higher likelihood of false positives. So if someone has a positive COVID test, or you've been told that they have a note saying they had COVID, you can remove them from the weekly test for a period of 90 days, but they still have to wear a face mask. The ETS also specifically, in case you're all wondering, because we haven't talked about this enough, what a face covering is that is required. And again, this is in instances where you as the employer have adopted the policy that we're not going to require mandatory vaxes. We're going to just say, we're going to go the route that if you vax, you vax. If you don't, you're going to have to test and cover your face. But it specifically defines that it's made with 2 or more layers, it's secured to the head. It fits snugly, can't be what my children call chin diapers. It has to be fitting over their face. You can have clear for those fashionistas that like the clear masks. You can have that, and it can be manufactured or homemade. Only employees who are not fully vaccinated are required to wear a face covering when indoors and when we're occupying a vehicle. So if you're vaxxed, you don't have to wear the face covering. If you're unvaxxed, you have to wear it unless you're alone in a room with a floor to ceiling wall and closed door. You're eating or drinking, you're wearing a respirator, or if you can show that it would create a greater hazard that would excuse compliance, which really relates to an industry specific issue.
So time off for vaccination. You need to provide reasonable time off during work hours for each primary vaccination dose. So the 2 doses for Moderna and Pfizer and the Johnson & Johnson dose, up to 4 hours of paid time at an employee's regular rate of pay. It can't be offset by accrued sick leave. So this is a separate and apart 4-hour allotment for each vaccine. It does not currently apply to boosters. And if the employee chooses to receive the vaccination on a Saturday evening, they're not required to pay for that time. Side effects. Employers are required to provide what the regulations say is a reasonable amount of time. So again, not a lot of guidance, but employers may require use of accrued paid sick leave when recovering from the side effects of the vaccine dose. But if the employer has multiple types of leave, they can only require an employee to use the sick leave, and the employer can set a reasonable cap on time to recover from the side effects. But the ETS doesn't specify as to what that means. So if an employer provides up to 2 days of paid sick leave for primary vaccination, that I think that would be in compliance. So, again, reasonable. Employers can't require employees to advance their sick leave. So if someone is 0 to go into the negative, borrow from next year, or that sort of thing. So employees must promptly provide notice when they're diagnosed with COVID, and this needs to be included in the policy. They need to be immediately removed from the workplace. Again, there's no requirement to provide paid leave when removed for close contact, or do contact tracing. If the employee is removed and can work remotely, that can happen. You have to keep the employee out of the workplace until return to work criteria are met. There's a negative test result. They have a return to work clearance from a licensed healthcare provider, or they meet the return to work criteria in whatever is the then current CDC guidance. So record keeping. We've talked a little bit about this, so I'm going to go over this quickly, and you'll have these slides. You need to have that vaccination record and the roster. And an employee or an employee representative can request the aggregate number of fully vaccinated employees at the workplace, along with the total number of employees. You wouldn't provide names, just information along those lines. You're not required to submit any of this documentation to OSHA, but if OSHA comes knocking on your door, you need to be in a position where you can provide it within 4 business hours of the request.
The usual OSHA record keeping and reporting obligations apply. So your 300A logs, you need to make a reasonable inquiry into whether an employee's COVID positive or COVID diagnosis was work related. You can ask them questions. I mean, if somebody comes in and says, oh yeah, I was at a party over the weekend and everybody got COVID, you can make a reasonable determination that was not work related. On the other hand, if an entire department has gone down with COVID, reasonably likely that's work related. You also have reporting obligations, which is when you have to literally pick up the phone and call the local OSHA area office. 24 hours if you learn of an inpatient hospitalization for COVID, and within 8 hours of, and actually that should be a fatality there on slide 46, within 8 hours for a fatality. And just because we want to leave you with this completely uplifting note, what can be the exposure if you decide you are not going to comply? There are penalties, and these are the penalties that are currently in place for all of OSHA's standards. These are not unique to this particular ETS. Right now, if you have a serious or other than serious violation, you can be fined up to $13,563 per violation. If you've been through an OSHA process, there's some wiggle room there, but that's the max per violation. And if it's willful or repeated, it can be up to $136,000. As of right now, there is a proposal to drastically increase the OSHA penalties. The penalties have not increased by law in a long time. They just kind of have an inflation that happens each year. But President Biden and the Democrats' pending proposal for the Build Back Better plan does have a proposal that it would go up to $70,000 per violation and up to $700 for a willful or repeated. That's not the law right now, and fingers crossed that number will not change to be that high, but just FYI.
Okay, so now we're going to talk briefly about exemptions. Obviously, as part of this policy that you're putting together, you must provide exemptions for disability or religion. These are required by federal law under the Americans with Disabilities Act and Title VII. I saw someone asked in the questions, do you have to do this? Yes, you do. So you must provide an accommodation process for individuals who have medical conditions or disabilities, and there's a contraindication to the vaccine. So as part of your policy, you're going to list that, and then you're going to provide exemption forms for both to employees and provide a deadline for when those exemptions need to be provided. With respect to medical, you need to get an understanding as to what the basis is. You're going to want to ask for a documentation from a provider as to why it is the person can't get the COVID vaccine. You'll have to assess that on an individualized basis and then determine whether you have sufficient information. If you don't have sufficient information, then you're going to have to go back and ask questions, gather information. This is your usual accommodation process to be done by human resources. And so you should be familiar with what that process is. Obviously, if you provide that accommodation to the employee, as Angela said, they need to test. With respect to religion, you also need to determine whether someone has a sincerely held religious belief. You cannot require a clergy letter for that. You again provide a form, ask them to describe what their religious beliefs are, and then you assess whether and to what extent they've articulated a sincerely held religious belief. And again, with respect to both disability and with respect to religion, then you have to assess whether it's an undue hardship to accommodate that request. If you're testing other people and testing is an option, then you're going to be hard pressed not to accommodate with testing. But you do have to assess that piece of it, because we lawyers like to make things difficult sometimes. And the government, they have different standards for the ADA, what an undue hardship is and what Title VII undue hardship is. But as you're working through that, if you have any questions, you need any advice as to how to proceed in that regard, you can feel free to reach out to us. If you have information from an employee previously and it's inconsistent with what they're telling you. So for example, if you know someone has gotten many immunizations in the past and now they're saying they have a religious belief, you can conduct a reasonable inquiry to them and say, can you please describe and explain what the basis is? We have your medical record in employee health and you've gotten vaccinations for the last 20 years. And so you're not required to accept at face value what they say. You can ask questions.
Okay, so we covered the ETS in just about an hour. There are still a few questions in the Q&A, and we will do our best to hit those. I'm going to give a quick federal contractor update. I know this does not apply to all of you, so you're certainly welcome to remain on or put questions in the Q&A. But I do want to give a brief update on some other vaccine mandates that are in place, the first of which is the federal contractor vaccine mandate, because we do have some attendees who this covers. Earlier in September, there was an executive order issued that basically directed that federal contractors were required to comply with guidance issued by a task force that had been created by the White House. It's basically a task force that is issuing requirements for both federal employees and federal agencies, so employees of the federal government, and businesses and companies that enter into contracts with the federal government. And this is a very different enforcement mechanism than the OSHA ETS. Here, this is basically being handled by inserting new contract terms into the contract that a business has with the government. And essentially what the government is saying is, if you want to do business with us, you need to put this in your contract. And if you don't want to put this in your contract, we'll go find someone else. So very different than a general workplace safety analysis that OSHA is relying on. There have been lawsuits filed concerning these requirements, but so far, no court has put a temporary stay in place. And so these requirements are going forward. And again, because it's such a different legal mechanism that the government has to put this requirement in place, it's going to be a very different analysis by the courts. So who does this apply to? The executive order really is focused on service contractors and the concept that when it's doing business with companies that are coming onto federal lands or interacting with federal employees, there is a concern about preventing that from spreading COVID to federal employees. There were exceptions for contractors who are really just producing products or in other roles where they were not interfacing with federal employees or federal property. However, at this point, we are really starting to see the tide turn on that. The task force has basically issued a recommendation that all federal contractors, including those that are not specifically required by law, should be asked to comply with these requirements. And in particular, when we did our COVID update a month ago, we gave the recommendation, or at that point, the law was that if you're only providing products, or you have a small contract that is underneath certain dollar thresholds, you don't have to worry about this. And now, lo and behold, you do. The general rules are that the new contract term is going to be inserted for new solicitations and new contracts after October 15th. The bigger issue is for those contractors who have contracts currently in place. What do? Because realistically, you're bound by the terms of your existing contract. And the government, neither party really should be able to change what that contract says midstream. So for existing contracts, at the point in time where your contract comes up for renewal or extension, or the government to exercise an option to have it continue on, at that point, the clause will be inserted. However, General Services Administration, which is the agency responsible for handling most federal contracts, is already, regardless of whether it's up for renewal, is going pretty much back to most contractors right now, including contractors that are not specifically covered by the executive order, and asking those contractors to modify their contracts to include these terms basically midstream. And I have an example of the cover letter that General Services is planning to send out to contractors. Some have already received it. Others, this letter is up on their website, and they're making two things clear, which you can see in the red boxes. If you are a contractor that is specifically covered by the executive order, they're asking you to modify your contract now, and they're putting you on notice that they will not renew or extend your contract unless you agree to this language. And if you are not a contractor who's covered by the executive order, in particular, you are only producing products or you are below the financial threshold, they are strongly encouraging you to agree to the modification. So now you have to make this decision. Well, if I don't have to now, should I? And that's really going to be an individual business decision. Legally, do you have to accept the modification? No, not necessarily. But if this is a big part of your business and having this government contract is vital to your continued operations, and you kind of have to assess, well, if I make them mad and they go elsewhere, or they decide they're not going to renew with me, can I sustain that? Do I want to take that chance? If you are a lower tier sub, you may not have a choice, because if your prime contractor decides they're going to accept the modification, they have a flow down obligation, and they're going to be coming back to you attempting to have you insert this in your subcontracts as well. So it's really, I can't say here on the webinar, yes, accept it, don't accept it. You have to really think through what the importance of this contract is in your business operations, what your relationship is with your contracting agent, whether they're giving you any off the record information that they're going to be okay if you don't accept the mod, but when you come up for renewal, they're going to require it, and really make a business decision on whether to accept that or not. Quickly, who's covered? It's two primary categories of people that need to be vaccinated. It's employees who are working on or in connection with a covered contract, regardless of where they're at. So that includes remote workers who are at home. And the second category of covered employees is employees who are working at a covered contractor workplace. And a covered contractor workplace is anywhere where someone who is working on the contract is likely to be present. So most likely most of your workplaces, if you're a federal contractor. Originally, the compliance date for vaccination was December 8th. That has been moved back to January 4th to match up with the ETS date. This is just a little point that was announced at a White House press briefing. So we're still waiting for the task force to actually publish that as part of their guidance that they are moving the date. But at this point, the White House has made it pretty clear that's what the expectation is. And one point here I just want to bring up, because I've actually had quite a few calls about it in the last couple of weeks, is corporate affiliates and these arrangements where subsidiaries or sister companies are sharing workspace. One is a federal contractor, one is not. The task force has issued guidance that if you are affiliated entities, meaning either one entity controls the other or both of them are controlled by a third party, and they share office space, and one person's a covered contractor and one is not, the requirements are going to extend to the other business. So I've given you two examples here where basically two entities are controlled by a third company. They share an office space. One's a contractor, one's not. The non-contractor is going to be considered an affiliate of the contractor and is going to be expected to comply. So if you have any of those arrangements, you need to be prepared that even if you're a non-contractor, you may get scooped up into the coverage of this requirement. And then a very quick summary of what's required. You have to confirm vaccination status and require vaccination. Unlike the ETS, there is no off-ramp for testing. It's not an alternative where you vax or test. It's you have to be vaxxed under the federal contractor standard unless you have a religious or medical exemption. There's not just a general, I'm choosing to not get vaccinated, so I'll get tested instead. Prime contractors do have an obligation to include it in their subcontracts and to ensure that the obligation flows down. And they have to enforce it. They can generally assume that their subs are complying, but if a prime contractor receives evidence that a sub is not, they're going to be expected to take action on that. And federal agencies will have the right to terminate contracts with contractors who do not comply. Last point I want to make before I get you out of here is there were several questions in the chat, and we did mention early on that the Center for Medicare and Medicaid Services also issued regulations on November 5th. There were just too many things to get all into one webinar, and that is kind of a separate set of regulations. But if you are a healthcare provider and you are considered a certified Medicare or Medicaid provider, meaning you are accepting funds through CMS, there is an additional regulation that requires a vaccination program for employees. It is different than the OSHA healthcare ETS. It is different than the vaccine or test ETS that we just talked about today. And that is something we will also be helping clients with, both our employment department and our healthcare department. And if you fall into that category, that's something we can help you out with. We didn't want to keep you all afternoon. So thank you very much, everybody, for your time. We will be distributing the slides, and we have looked at your Q&A and are doing our best to answer those. We hope that this was helpful for you. And again, if this is something you're grappling with as a company and you need assistance in figuring out how to approach this, how to tackle this, and how to implement your compliance, Andrea, Theresa, and I will all be happy to assist clients with that in kind of putting you in the best position possible to do something that works for your business. So thank you again. We're going to hang around for a minute or two, and we appreciate your time this afternoon.
Thank you very much, everyone.